I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introduction to open meeting law, our latest round of video tutorials and other lessons on freedom of information laws in New England. If you haven't already, please check out our previous lessons on public record laws and the Federal Freedom of Information Act. All lessons are available to view at nefac.org/FOI guide. In addition to more video tutorials, you'll also find there other helpful resources such as common Q&As, notable case law, and an FOI legislation tracker. This round of lessons is brought to you by NEFAC with help from the Society of Professional Journalists Foundation, the Rhode Island Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. We're grateful for everyone's support. Thank you. Now, here's NEFAC's Emily Sweeney to introduce you to your instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on freedom of information laws. This session is going to focus on the open meeting law in Massachusetts. And with us is John Albano, a partner at Morgan Lewis and an expert on this topic, who is going to give us a good overview of the open meeting law in Mass. Thanks so much, John.
Of course. Thanks, Emily. So the open meeting law, as I'm sure you all know, requires that many, not all, but many governmental meetings be open to the public and that a record be kept of them. In Massachusetts, I'll just tell you, there is a great, the Attorney General has enforcement powers over the open meeting law, and she has issued a great guide that is on the Attorney General's website to the open meeting law, including, the email of the person of the division at the AG's office that you should call if you run into a problem with the open meeting law, and a very user-friendly summary of the law. But basically what the law requires is that these governmental bodies have to give some prior notice before there's a meeting, and that the meeting should be generally public. The AG, as I said, has the power to enforce the law. She can impose fines for knowing violations. She can bring a lawsuit. Massachusetts has a weird law that says civilians also can bring a lawsuit, but you need 3 registered voters in order to bring a lawsuit under the open meetings law. The Attorney General also has said that any member of the public can make an audio or video recording of a public meeting. You just have to notify the chair beforehand, and the chair is supposed to announce to everyone that the meeting's being recorded. If you show up late, the guidance is just try and discreetly pass a note to the chair, let them know that you plan on recording the meeting. The Mass law applies to public bodies. That's what the law says. And it's basically a whole variety of boards, commissions, subcommittees within the executive branch. Some legislative branch subcommittees are subject to it as well. The classic examples are Board of Selectmen, City Council, School Committee. There are some important government entities that are not considered a public body under the open meeting law. The legislature is one of them, again, with the exception of some subcommittees. And the judiciary is not covered by the open meeting law either. There's a couple other exceptions if, the governor or the governor appoints a board, like the Judicial Nominating Committee, to give him or her advice on who to appoint. Those types of advisory committees are not considered public bodies. If a school superintendent appoints an advisory board to try and help with the selection of a new principal, for example, those aren't covered. But there are a wide variety of kind of local and state commissions, boards who are covered by the open meeting law. In order for the law to kick in, there has to be a deliberation. And a deliberation just means that oral or written communications between members of a quorum of the board. So you need to have a simple majority present. It's a 5-member board and only 2 are present, there's no open meeting law. But if you get 3 out of 5 and there's a deliberation, which just means you're talking about public business before the board, then the open meeting law kicks in. There's some exceptions that are sort of common sense. If you're just distributing agendas or doing pure scheduling, it doesn't count. There was a case a few years ago involving the Massachusetts Gaming Commission, where they had someone sued them under the open meeting law because their calendars showed that there were a quorum, 4 out of 5 in that case, commissioners attending a 3-hour applicants discussion, and then another event where they had, it was labeled advisory group brainstorm. And the commission apparently thought those are just too preliminary to be meetings, but our state Supreme Judicial Court said, no, those look to be from the calendar like it's a deliberation, because you're really talking about policy matters related to subjects that you deal with at the commission. And so the open meeting law applied. There's a trick that some people have tried unsuccessfully. They're sometimes called walking quorums or rolling quorums. So the city council, Boston City Council, for example, had this system set up where they'd have 2 counselors in a room, a guard at the door. They'd talk to each other. One would leave, a new person would come in, and so on and so forth. So they never had a quorum present in the room at the same time, but it was obviously just a scheme to avoid the open meeting law. And so the court said, no, you can't do that. If you're having one-on-one discussions kind of serially in order to avoid the having a quorum present, that doesn't work. That counts as a meeting, and the records would have to be disclosed at that point. That's all they had was the records. There are some exceptions where even if you have a quorum, the open meeting law doesn't apply. Boards and committees can go on-site inspections of a project or some program as long as they don't deliberate. They can go to public or private gatherings, seminars, conferences, again, as long as they don't deliberate. But if you invited a quorum to your house for a holiday party and they started talking about public business of whatever the committee or commission was, then it would count. Then that exception would not apply. There's a couple other exceptions. There's quasi trials that agencies do at times. They can deliberate in private about those. It's sort of analogous, I guess, considered analogous to jury deliberations. There aren't that many commissions that decide adjudicatory hearings, what they're called, sort of administrative trials. That's an exception. Town meetings are an exception. They're usually open by tradition, but the open meeting law does not apply to them. There is a public records aspect to the open meeting law, because the law requires the public bodies to create accurate minutes of everything that happened, including votes. There can be no secret ballots under the open meeting law. You have to say who they are and what their position is on whatever the issue is. And any transcripts, documents, exhibits, photographs, maps that are used in the course of the meeting, those are all considered public records. There are some exceptions to the public records aspect of the open meeting law. They're sort of personnel related. So if you if there are materials you're using in a performance evaluation, then those are not considered public. That's similar to the public records law, where personnel records are exempt. And materials used in deliberating about an appointment, including applications and supporting materials, those records are not public, but any resume submitted by an applicant, the statute says that that is public. So that's the kind of public records aspect to it. The most common fights under the open meeting law concern the rule about closed executive sessions. So a public body is allowed to go into these closed executive sessions. They have to start out in an open session. They have to announce that they're going into an executive session. They have to say why they're going into an executive session, and they have to take a vote of everyone there before they're allowed to go into an executive session. They have to keep records of the executive session. They still have to vote on the record. And they can only talk about, the statute says you can only talk about whatever that subject matter was that justified going into an executive session. And there's, you wonder why some people complain about the open meeting law. There's 10 different reasons why a public body is permitted to go into executive session. The first is if you're discussing the reputation, the character, or the physical or mental health, rather than professional competence of any individual. Or if you're discussing whether that individual is going to be disciplined or not. You can go into an executive session. The justification is to protect people's reputations before a decision has been made. Strategy sessions for negotiating with union or non-union members. You can go into executive session. It's just so they don't lose their negotiating power. You can also go into executive session to discuss litigation. If there has to be the board has to say, well, if we talk about this in open, it could hurt our position. So let's talk about this in executive session. Security issues, criminal decisions about whether to initiate criminal charges or criminal investigations. If you're going to try and sell a piece of land or any other property, again, I think the theory there as well, there's a potential buyer out there. We don't want to let them know what our real bottom line number is. And I think the other trade secrets, if that comes up, some energy in the energy field, if the government entity is in the energy business. The other one that comes into play, it's, I think from a news gathering purpose, too bad, is you can go into executive session to either consider or interview applicants for some type of employment if they're in the preliminary screening process. But once you're talking about applicants who have passed the preliminary screening, you can no longer go into executive session. And there, I've always assumed the purpose is if I'm applying for a job, but I'm not a finalist, then maybe my employer shouldn't know because I might not make it out of round one. But that's a provision of the statute that sometimes excludes people from what might otherwise be an interesting public meeting. Again, they do have to keep records of those executive sessions, and if they went into executive session because they were going to sell a piece of land and the land got sold 2 months later, so the purpose of the executive session no longer applies, then those records are supposed to come out. Probably the biggest development is recently has been COVID related. The statute initially said, and the Attorney General said this as well, so there was very limited use of remote hearings, meetings. And I think both the statute, but definitely the AG's regulation said you needed a quorum, so a majority of the members physically present, and maybe some would not be, and then you could do a remote hearing and allow remote public access. With COVID, that has changed. There's been a series of statutory amendments. In July, the governor signed another one that extended this sort of broader remote access to public meetings through March of next year. There's a movement afoot to make it permanent because it's so much easier for citizens to participate or observe, even if they aren't participating, and probably for the press too, when the hearings can be done remote. They have to be, the statutory term is adequate alternative means of providing remote access. So it can be Zoom, it can be Facebook Live, YouTube Live, even local TV. The AG has said would be sufficient. If a town or municipality says we can't afford it, we're too strapped for cash, they are allowed to just make a transcript of the hearing and meeting and then make it public. But the AG has said, basically check with me before you do that, because I want to make sure it really is financially impossible for you to do many of these relatively easy remote access alternatives. As I mentioned, the Attorney General is responsible for enforcing the law. They can investigate complaints, they can issue advisory opinions, they've got regulations in place, they can bring enforcement actions. But if you run into a problem, if you're thrown out of a meeting you don't think should have been closed, then the steps, and they are in the AG's guide. So if the problem comes up, you can always look at that. But I'll tell you generally what they are. You first file a complaint with whatever the public body is. And you have to do that within 30 days of what you think is a violation. And there's a particular complaint form that's on the AG's website. And you're also supposed to, the instructions are there too. You don't need a lawyer to do this. Or you can use a lawyer, but you don't need a lawyer. You also have to, if there's a municipal clerk, you've also got to give a copy to the municipal clerk. Say it was the school committee. You say to the school committee, here's my complaint on the form the AG has given me to say I was wrongfully excluded from this meeting. And you go to the municipal clerk and you say, here's a copy. The public body has 2 weeks to respond. And you have 30 days after your complaint is filed to file another complaint with the Attorney General and see if the Attorney General will pursue the matter. You'd explain why you weren't satisfied with the response you got in 2 weeks, and 2 weeks after your complaint, and see if the AG won't move on it themselves. They have a division of open government that handles these things, and they do a decent job at it. They can impose, I think that they can fine the government body up to $1,000 for a willful violation. And as I said, if they don't get any relief, or if you don't get any relief and you're a registered voter and you have other friends who are registered voters, you can, as the AG can, bring a claim in court to get an order that would, the orders usually are things like, okay, you get the records of the hearing and the minutes of the hearing, if you win. And then there's some type of sometimes injunctive relief that, like, for example, the city council case that I mentioned where they were bringing people in a room 2 at a time. They kept doing that after a judge had told them not to do it. So that judge had entered an injunction, then they violated it. And then the case went up to the Supreme Judicial Court. So it's, I would say the enforcement, if I had to generalize, I think if there's an open meeting violation, the AG is more apt to act than when there's a public records problem. Maybe that's because there's more exemptions to the public records law, maybe because public records issues tend to be more complicated or contentious. But I do want, whereas if we go to the supervisor of public records, when we've got a public records law, those of us in Massachusetts know that while that office issues some good rulings, they're all toothless. They can't, I mean, these days, at least if you win at the supervisor, you go to court and you win, you can get your attorney's fees. But there's really not much of a downside for a government entity to say to the supervisor, that's your opinion. I think I'm right. I'm not going to produce these documents. And the AG, of course, has the authority to get involved in public records disputes. And this one has on occasion, but it's more unusual. I think the open, what it's called, Open Government Division of Open Government is more apt to take action on an open meeting law problem than on a public records law problem. So that's kind of the overview. If there's any questions, I'd be glad to answer them now or after, if you want to email afterwards.
Yeah, John, thank you so much. I really appreciate it.
Good to see you.
All right, take care, everybody.